Good morning. See, initially, bail applications were regulated under 436 and 437 and 438 CRPC 1973. This anticipatory bail was not available when 1898 CRP was in force. But when an advocate was apprehending arrest, the first time the Madras Sessions Judge seems to have, Madras High Court seems to have given a direction directing the said advocate accused to surrender before the lower court, and to the lower court was directed to consider the bail application instantaneously. That the said order is now being passed in EC ST Prevention of SC/ST Atrocities Act. You understand? Thereafter, what happened? The first act which was introduced prior to NDPS Act and this SC/ST Atrocities Act, there was an act, Essential Commodity Act. Essential Commodity Act, whenever you file bail application, you need not file bail application under 436 or 437 or 439. You have to file under section 12AAA of the Essential Commodity Act, wherein there is a tag that notice should be given to public prosecutor, and the public prosecutor, if oppose the bail, it is your duty to satisfy that there is no prima facie material that the petitioner accused committed offence. The same provisions have been later, little long years after, section 37 was introduced by amending the NDPS Act, constituting the Special Court Act. Similarly, Prevention of Money Laundering Act is also containing the same provision under section 45. Leave that alone. That is for your knowledge, and if you are preparing for assistant public prosecutor examination. But the confession given to police officer is inadmissible under section 25 of the Indian Evidence Act. But later, when confession before these officers other than the police officials considered as admissible, and later that was also being interpreted by the Supreme Court time and again, and saying under what circumstances the confession before other authorities other than the police officer is inadmissible. Here a different ratio was given by Justice B.R. Gawai, the designated Chief Justice of Supreme Court, wherein this concept, they say, person in custody cannot be considered as a person operating with a free mind, making such statement admissible against the maker would be contrary to the principle of fair play and justice. That concept is introduced AR 2024 Supreme Court 4286, AR 2024 Supreme Court 4286, Prem Prakash versus Union of India, through the Director of Enforcement, other things. And therefore, as an assistant public prosecutor, you are going to opt for and apply for, must know these provisions of PAMLA, Prevention of Money Laundering Act, section 45, 24. So many provisions are there. And they say they have the same provisions of like section 37 and 12AA of the Essential Commodity Act. This 45 are being operated. So many discussions were there. It is your duty to go through the entirety of the judgment once, twice. Several judgments already been discussed. If you go through the judgment once, twice, thrice, and by after downloading the judgment and underlining its important portions, you can input or write your result in theoretical way. It will be most helpful for you. I hope you understand. Best wishes.